You're listening to QSBS Solved, where we share insights for founders and investors looking to maximize their business's growth, exit opportunities, and tax savings. Our team at QSBSrollover.com offers specialized services to help you benefit from owning qualified small business stock. Our podcast guests are leaders in their respective fields and work on every side of the startup journey to help founders and investors win. The ideas and opinions shared here are not investment, tax, or legal advice. Reach out and we'd be happy to connect you with a qualified advisor or tax counsel. For now, enjoy today's episode. Hey everyone, welcome back to another episode of QSBS Solved. My name is Brady, and today I am glad to have on tax attorney Mark Melton, who is at Holland and Knight in their Dallas office. And Mark serves as the co-chair of the executive comp and benefits practice group there. And we're also on a QSBS study group together, or in a QSBS study group together. And it's great to have Mark on.
Thanks for having me. Glad to be here.
Yeah, we're also part of QSBS study group together. And so I thought it'd be cool to get on and talk through some of the issues that have come up in that group and just talk through some of the things that you see when working with founders and investors on transactions, capital raises, QSBS specific issues. So why don't you just give a real brief background about how you got sort of narrowed in on this area of the tax code, and this particular type of client when you're talking about maybe startups, investors, entrepreneurs, business owners, that kind of thing.
Yeah, well, Holland and I obviously is a large law firm, and so we're into all kinds of different investment vehicles, and so we've long represented private equity, many of which have 1202 investments, even some specific 1202 funds. And so for a long time, we've dealt with 1202. Since the OBB passed in July, there's been kind of a renewed interest in 1202 because of some of the liberalization of some of the rules. And so we've written quite a few articles on what are the updates and what do they mean and what are the inconsistencies in the statute. And I think perhaps more about new confusions than new answers. But we've been spending quite a bit of time with 1202 lately, even more so than in the past.
Yeah, we were talking just briefly before we got on about some of the inconsistencies and gray areas of the text of Section 1202. And this is just maybe sort of an opinion question. You can answer it however you want, but do you feel like the text got more clear in any way, or just all around more weedy? What do you think were maybe some of the helpful additions or otherwise that were made during this change?
Yeah, I mean, some of the additions were helpful substantively. For example, from 10 million to 15, with inflation adjustments, is obviously a taxpayer-friendly move. Increasing the gross assets test limitations from 50 to 75 million, pretty taxpayer favorable. I don't know that it added any more clarity to any of those issues that were already there. And if anything, it muddied the waters quite a bit with how they drafted this statute, specifically in 1202A6, which has led to a lot of conversations in our tax study group and elsewhere about what does this actually mean. I spoke with one of the lawyers that was with Senator Cornyn, who helped draft, the amendments and OBB, and brought up some of these questions to him and said, "You guys think about this?" And he said, "No, we didn't even realize that we were doing that until it was too late." So we've got a statute that has a bunch of holes in it, a bunch of inconsistent statements, directly inconsistent statements with itself, and nobody really thought about it or intended for it to happen. But here we are, stuck with it, trying to figure out what the right answer is and advise clients.
Yeah, what does that mean, I guess, for clients when you come up against issues in the code where you may talk to three different advisors, three different counsel, and they may have three different answers for how to proceed, what the strategic opportunities are, what the risks are, in best way you can. How do you think through how, if you put yourself in the client's shoes, how they should arrange all that information they might get?
Before I was a lawyer, I was an accountant in-house with a large private equity fund. And so I dealt with a lot of lawyers from that perspective as a client, and nothing frustrated me more than tax lawyers that would, give me a treatise on, here are the options with all the available, pros and cons and risks. Um, and if you're not an expert, you really, even if you have that information, you're not really able to parse through it and make an informed decision. And
It's
so
like
in my own
which
practice, I've always remembered that.
they say, which do you want to choose? And you choose one, and they're like, "Are you sure about that?" No.
Exactly. And so it's, I try and advise clients to say, here are your options. Here are the real risks and opportunities. And by the way, if I was you, I'd probably do this one, and here's why. Which, not a lot of lawyers want to do that. But at the end of the day, our job is to help clients make business decisions, based on the law and the facts. And if they're not understanding what I'm saying to them because I'm being cagey, I haven't really done them much of a service.
Maybe your answer to this question is similar to the one you just gave, but how do you help clients quantify, quote unquote, risk around some of the positions that you may take or some of the structures that may get set up? I don't really like the word risk. There's there's levels of ambiguity, amounts of clarity on a given position or situation. But the word that we often hear is risk. And so how do you talk about that?
I mean, I think the word risk makes sense, right? Because that ambiguity could lead to you writing a check to the IRS, right? So that's your risk, is that you misinterpret the ambiguity and then it costs you money. When I look at transactions and structures and, various alternatives, what you're really trying to look at is how sure are you that that's an acceptable answer? In the tax world, there are levels of comfort that we always talk about, right? And they kind of vary. On the low end, do I have a reasonable basis to take this position? A reasonable basis is actually pretty unreasonable because it just means you're almost certainly going to lose if this gets audited, but it's not crazy. Like, there's a colorable claim there. It's just not very good. And you can ethically put that on your tax return as long as you disclose to the IRS that you're taking a really risky position. And so when I'm advising clients, it's not an exercise of a black and white option, right? Where you can, this is right and that is wrong. It's a question of, how well are you going to sleep if you know that there's a greater or lesser chance that the IRS might audit you, and if they do, what they're going to say. And that level of comfort runs up, right, to the next level is substantial authority, which just means, roughly, if I was to quantify it, I got about a 1 in 3 chance of winning if I litigated this in the tax court. And I can put that on my tax return without making any special disclosures, and that's completely ethical, right? So I'm looking at risk analysis in terms of what is an ethical position first, and then am I comfortable with all the pros and cons of that ethical position. And by the way, if I only have a 1 in 3 chance of winning in the tax court, that means I got a 2 in 3 chance of losing. So I can have a position that probably is wrong, and still ethically put it on my tax return, as long as I've got some substantial authority, which just means there's something out there I can point to that supports the position. There might be another case or something that doesn't support it, but I got something I can hang my hat on that's, quote, substantial. And then it goes up from there to more likely than not, which, doesn't mean 50-50. It means more likely than not. And so there's only one of those in any series of transactions, right? On what's the most likely one when. But you can have a transaction where there's a position that is more likely than not, and there's a completely opposite position that might still have substantial authority. And so I can make a selection ethically between those two choices and put it on a tax return without any special disclosures even. And I just have to understand, and that's what I try to do with my clients, is help them understand, what does that mean exactly? If I take a substantial authority position when there is a more likely than not position that is the opposite, And what are your real risks, and how well should you sleep at night if you decide to do that?
I think that's a great synopsis of how to evaluate risk and what the tax and legal opinions offer in terms of mitigating risk. Because if you can get one of these strong legal opinions, you can actually limit potential penalties and other fees that could be imposed. The IRS finds that you took a position that you shouldn't have. That's the case, right?
It's not quite an insurance policy, right? Because
Mhm.
the opinion has to be reasonable, and there's some subjectivity after the fact in some of these things. And quite frankly, in 1202, there are some things you could issue a high level of comfort opinion on. There are a lot of things, usually the things people want you to issue an opinion on are very much in the world of gray. And the assurances that that is the correct answer are usually you're not as comfortable. And so it's harder to issue those high comfort opinions on some of these issues.
In the types of things that folks may ask you about with regard to your opinion on QSBS for 1202 are going to vary pretty drastically between whether or not it's maybe a startup asking you for some of this opinion work, or maybe it's a fund manager with a bunch of LPs and different types of transactions, and a lot of changing of the cap table over time of the fund structure. Maybe what are when you think about the gray areas for startups versus the common gray areas that you encounter in your private equity work or with fund structures, are there differences? Is it mainly transactions on the fund side, and then it's mainly like business activity on the startup side?
Yeah, I think that's right. I mean, when you're starting up, it's pretty straightforward, right? With the one exception of, do I have a qualified trader business?
Hmm.
Yeah, and even some of those are pretty straightforward, but sometimes they're not. And so, that's an area where you got to think about a little bit. Um, and it's kind of one of those things where you're going to start a business most of the time anyway. And it's not really being driven by whether or not it's 1202. You just kind of want to know if it is. And if so, you want to plan accordingly going forward. On the backside of the transaction, right, those issues vary wildly. We've seen recently, issues with, certain redemptions coming into play, and whether or not that fouled up, the QSBS status on, issuances within a year of those redemptions. There's always questions, especially the fund space, around carried interest. We had one recently where the fund manager wanted to effectively crystallize their promote and then kind of move forward. And the question is, well, I just changed my partnership interest from the traditional promote waterfall structure to, something that is pro rata. And is that change in the partnership agreement tantamount to an exchange that would blow up your QSBS status? And you can make arguments both ways, but there's no guidance. And so it's really difficult to draw a conclusion with any amount of certainty. And so you really are just evaluating what is the risk of this, not whether it is definitely right or definitely wrong. And obviously the answer on partnerships is if you don't have to change something, don't do it. Um, that's the safest answer.
And for startup founders, especially in the early days where like even your founding team may be relatively fluid. Maybe someone joins and you incorporate together, but then they say, I actually don't want to be a part of this. And you have to be careful about how you dispose of stock, how you change up the cap table, even in those early days when you feel inconsequential, because you say, we have no revenue, the company's not super valuable. It's still early, but if you're planning to use that early incorporation as basis for your QSBS and your starting point for your QSBS holdings in the future, you really have to do your ducks in a row all the way through, right?
You do, and unfortunately, the answer is, and startup founders hate to hear this because it involves spending money.
Yeah,
but don't touch your cap table without consulting somebody that knows what they're talking about to confirm that it's okay, even if you think it should be okay. And in a normal business environment, it would be, not a big deal at all. The consequences are so dire if something gets messed up in a QSBS structure. it's worth a few dollars up front. Ounce of prevention being worth a pound of cure.
Yeah, I mean, obviously we hear a lot. It's like, well, we're not profitable. We have no money. How can we afford complex planning? Well, it's like, well, maybe you shouldn't have incorporated it. Maybe it was too early to incorporate and, make things real from the start. So do you often what's your advice for, say it's, three guys in a dorm room or whatever the equivalent is, when you're out of college in San Francisco and you start a company? Do you typically advise to, do something simple like a pass through, like an LLC structure to start? And then once you sort of have things going and understood and you're ready to raise capital, then you move into a C Corp structure. What do you advise?
Yeah, especially in that scenario where you've got three guys in a dorm room, for sure, right? Keep it simple, right? Is always the right answer. When you get to the point where you're going to actually go raise some capital, whether it's angel or the next venture round or something, that's when you start to think about converting to QSBS, right? That's kind of tempered with what is the scenario that you might sell this thing 5 years and a day from now, and every day that I wait to convert is a day I've got to wait to sell. I don't know that really should drive it because it's an unknown, right? And so, how complicated do you want your life on something that may or may not go anywhere? So let's make sure that we're actually going to take off from the runway here before we do something too complex.
Yeah, if you know generally what the commercial thrust of the business is going to be and who's going to be involved, maybe you're a little later in your career and you're, branching off to start your own thing, maybe possible to just incorporate the right way, but, QSBS eligibly right away and start your clock running, especially now under these new rules, which, give you some benefit at years 3 and 4, even if you hold for the whole 5 years. 5 years is a long time in any industry, let alone the startup space. That can feel like a lifetime for sure.
Well, the two most important factors in a successful business just generally are access to capital and experience.
Yeah.
The third one is luck. And so if you start off with the first two, usually you've got a few bucks to hire the right professionals to help you anyway, and your likelihood of success is much larger. If you're starting out with neither of those things, and it's kind of a hope and a prayer, that it's you can afford to wait just a little bit until you're sure that you need to spend the money.
Yeah, and money buys you time too, right? And time, I'd say time is the fourth ingredient there. Just staying in the game dramatically increases your likelihood of an outcome, right?
That's right. Well, that whole first leg of access to capital, like you said, it can buy you a lot of time.
Yeah, you work with a lot of capital allocators too, both on the M&A side, and I'll just call it private equity, when they're doing acquisitions or even minority acquisitions, but then also on the venture side as well. What kinds of questions? One, I know that private equity is more concerned about QSBS than they were 10 years ago. I talk with way more private equity folks today, even than I did 2 years ago when I started in thinking about QSBS. What kind of changes have you seen at like the capital allocator level, the fund level, in terms of the way that they think about QSBS and how they're optimizing for it? Is every fund optimizing for it today that you talk to?
No, well, it depends, right? There's different groups of funds. You got some funds that are going to be buying companies that are just too big to really qualify.
Too late stage, yeah.
And so, for those funds, their QSBS involvement really is as the purchaser trying to, benefit their seller, right? And their incentive is not their own, right? It's just they want the seller to be happy. And if they can juice the tax results for them a little bit, that makes their bid look a little more attractive. And so there is some flexibility on the buy side, kind of larger, more mature private equity funds to make some accommodations they would normally make. In a typical PE deal, right, there's going to be one holding company that owns the whole thing, and the rollover equity is going to go into that holding company one way or the other. And now you got these QSBS targets, right, where they say, well, I can't put my rollover stock into that holding company. And so we're starting to see a lot more private equity funds that are really getting it and saying, okay, we'll let you hold it outside. We'll come up with some other way to manage the business.
Do you do you see it just accommodations for like the exchange of stock, or do you see just a larger amount of straight cash up front? Are you seeing that as a trend, or is it really just different accommodations for an exchange?
No, it's really just different accommodations for an exchange. And you got to remember in private equity, this is a whole industry based on allocating capital, not really on running businesses. And so, as smart as some of these guys are, they're not necessarily in that industry full time, and they've got 10 other portfolio companies, right? So they're not the CEO. They need a management team, and they want that management team to be, locked in with that. So they want to see material rollovers for that reason. It's not because they don't have the cash to buy the whole thing. They could do that all day long. It's about incentives. So it's
Leverage and incentives is the name of the game in private equity, isn't it?
yeah, that's right. So they're not just writing bigger checks to solve a QSBS problem, right? They're solving it in other ways to keep those incentives aligned.
Even though we're, almost 16 years past the 2010 expansion of QSBS, I still sometimes hear people say, "Oh, I didn't even know that QSBS was that big of a deal for shareholders, employees, founders. I thought it was a venture thing. Like it was only funds that benefit, or it was only angel investors somehow that benefited." I'm surprised that that's still a sentiment in the space, and it's something I hear, and it makes me realize how early we are in terms of educating people about the opportunities around QSBS. Have you seen any changing or maturing in the way that venture funds help both their LPs and their portfolio companies understand tax optimization, those kind of benefits?
I don't know that I've seen a change in it necessarily because, if you were in that space, right, and you were a venture fund or even a small private equity fund that was focused on 1202 targets, right, the general idea of it hasn't really changed over the last 30 years. There was an exclusion, and if that's what you were focused on, you kind of structured around it and went for it. I think what we are seeing, especially in the last 6 months since OB3, is there's a whole lot more interest just because it's getting more attention and people are writing about it. And the news is writing about it. And I think people are waking up to this idea that, what do you mean I could grow a company and take the first $15 million of gain tax free? That's, as a tax lawyer, I get a lot of phone calls from people that have had water cooler conversations. And somebody has told them, you can do this transaction and save all this money in tax. And 99 out of 100 times, it's nonsense, right?
Yeah.
It's not professional tax advice. It's things you would go to jail for a lot of times. And so we have a lot of conversations saying, no, I'm sorry, that's not true. This is an exception to that, where it sounds too good to be true, but it's true. And it was the intended consequence that, Congress passed. And so we are having a lot more conversations than we have historically about either converting partnerships into QSBS or having startups start out as QSBS. We certainly are seeing a whole lot of private equity on the backside of deals that are now buying QSBS targets that are trying to exit, and a lot of interesting structuring issues going on there.
Yeah, I think the when people talk about it's too good to be true, I just think that's funny, because for me, that's just always an education thing. Like if you're not aware of something, it sounds foreign to you. I remember the first time I realized that when you sell your house, you can take a bunch of the equity upside tax free. I don't know if it's up to $500,000 or something for married filing jointly, or whatever the number is, but that sounded crazy to me. I was like, are you kidding me? I get, that all that money comes back to me tax free. That was just because I didn't know about it. And so I think about, sort of the same thing with QSBS. When you step back and think about the incentives on both sides, I guess the government gained to take, or the IRS, gained to tax you at the corporate rate, and, the amount of value that you really have to create to have a sizable outcome, the incentives seem to line up more when you step back from it. So hopefully it's used more often, and some of the strategic components of how to optimize are used more often going forward?
I was gonna say it's just, I mean, really, the policy behind it is just kind of a boon, right, for entrepreneurs, on the taxpayer side, because it's not narrowly crafted, right? You hear stories about 1202 is really to incentivize, capital to invest in new innovations and things that we want, right? We want the United States to be a leader in innovation and technology and invention. But it's so much broader than that. It's hard to say that the policy behind 1202 is really just that.
Yeah.
And I don't know that was an intentional policy or if this was just something that happened because I don't know if you spend much time in legislatures, but I do spend quite a bit of time in there. And if people knew how laws were made, they would burn the place down. It is not as intentional as people think, especially when you start making amendments and editing and changes going here and there. They're kind of negotiations where you're trying to piecemeal together a majority vote, and you end up with some pretty crazy laws. And 1202 is probably a pretty good example where the drafting on the statute is actually just objectively terrible.
It's
horribly written.
And that's why we had the conversation earlier about risk and sort of the different legal opinions in the gray area. Isn't because QSBS in some phantom world is inherently risky. It's that we have so little clarity and guidance on actually how to implement the poorly written text in the code, right?
That's right.
Yeah. That's interesting. When we talk to founders, they're especially about rollovers, QSBS rollovers. There's a lot of skepticism about what do you mean I can take this money and put it in a new venture and defer taxes or eventually exclude it? And it really has for us started to develop a philosophy internally about what is 1202 for. It is more around keeping money in the hands of really good capital allocators and innovators. And so that's how we think broadly about why does it exist? What's the purpose of it? What's the benefit of it? I want to see money stay in the hands of these founders who are moving the ball forward, right? So I think of it more that way than like allocating capital or encouraging the allocation of capital. I think of it as keeping money in the hands of innovators.
Yeah, I'm kind of a cynic, and I just think they had good lobbyists.
Yeah, well, it was part of it too.
So, I mean, you look at the real estate industry, right? They've had 1031 exchanges forever.
Yeah.
And even over the years, as the like-kind exchange rules have been whittled away to almost nothing, real estate like-kind exchanges are still very much there and alive, and people do them all the time. And this is the same thing, right? It's just it's a like-kind exchange of sorts, specific to startups. And so, and maybe to your point, if you were going to try to justify it, other than they had really good lobbyists, if you've got a subset of the population that are serial entrepreneurs and they are highly likely to take whatever proceeds they get and reinvest it in a new innovative venture, right? Those kind of probably are the people you want to have cash in their pockets because they're going to reinvest it as opposed to just sitting on a pile of cash and not using it for a productive use for the rest of society.
Well, and your second, third, and fourth startup has a higher likelihood of success than your first. So it seems that, the hit rate should actually be even better with the rollover capital, right?
Well, it gets back to my point about access to capital and experience, right, being the two key factors. And I think that's proved out by the second, third, and fourth ventures being more likely to succeed.
Recently, we had some conversations about, you and I had some conversations about when startups are raising capital, especially when there's high demand for not a later stage round, maybe a growth round, say like a Series B, and you have high demand for the round and maybe the founder is able to take some secondary. There's some particular issues there that I just wanted to mention briefly and maybe have you say a few words about, which is when a founder is selling their stock, maybe as a secondary transaction during a fundraise, they're selling common, but often the money coming in and purchasing their stock, those are outside investors looking to have preferred equity. And we've run into a few instances recently where founders have had a lot of questions and their corporate counsel has had questions about the QSBS eligibility of the of the money coming in to the deal. I just wonder what you might be able to say about that in terms of how that can be handled, what the opportunities are to preserve everyone's QSBS all the way around.
Yeah. Well, I mean, like any tax issue, the facts matter, and every situation is a little bit different, which again gets back to this risk analysis. And since there is so little clarity in 1202, what tax lawyers and accountants generally do is we sit there and we look at a scenario and think, what's the worst case scenario? How could the IRS, if they wanted to, recast this transaction or treat this transaction in the worst possible way for the taxpayer? And this is one of those examples where there's not really a rule that says bad things happen if I sell common and it immediately gets converted to preferred. But you sit around and you think, well, what's the substance of that transaction? And one of the ways you think about this, how could I achieve the same ends by doing it differently, right? And one of those ways is the company could have issued new preferred stock, taken that cash, and then redeemed you out. That's one way to achieve the exact same. It puts cash in your pocket, and the purchaser gets preferred stock. If that were to happen right now, you've got to think, okay, well, does that redemption damage my ability to take an exclusion under 1202 for any other issued stock in the past year or in the future? And maybe that's a problem. Some other people look at that transaction and they think to themselves, well, the common is worth less than the preferred, right? Because of the liquidation preference. And so if I was able to sell this stock at the same price that the company could have issued preferred, then there's an inherent premium in there. And what is that premium that I just received as the founder? Was it really proceeds for the sale of my common stock that in theory isn't really worth that much? Or is it some kind of incentive compensatory payment from the buyer to the founder? It's an argument. It's not crazy or anything. There's no guidance in 1202 that says that's the answer. There's also no guidance that says it's not. But I kind of look at those again. We're assessing risk. Could the IRS take that position? Sure. It's risk. Could you make a straight face argument that, well, if I'm the founder and I convert my common into preferred, can I do that on a tax-free basis as, any reorg? Probably. And could I then, if I had done that, go out and sell that into the market at the same price? Sure. You could do that. And so can I make an argument that I could piece those two things together and say, well, that's not really compensatory. I took advantage of an exclusion under the reorg rules in subchapter C, and then cashed it out. You can make that argument. But again, just as there is no authority to say that you absolutely have compensation, there's also not really any authority to say you don't. And so again, you're trying to determine, can I ethically put this on my tax return? Is it so crazy that it would be fraud, right? And I don't think the answer to that's no, right?
Yeah.
In that fact pattern, I don't think you're anywhere close to that. And once you get past that, then you go, well, is it a position I can take without subjecting myself to some wild civil penalties for just taking an aggressive position? And now you got to think about it a little bit more, right? Because that layer of gray is a little thinner than, did I just jump into a fraud category versus am I just taking something that I ethically can, which happens to be aggressive? And again, the facts matter. So we want to look at each one individually, which is the answer everyone wants to hear on a podcast is nothing valuable. We'll figure it out later.
Yeah, but to that point, this isn't necessarily something that should keep founders up at night, right? It's your job to look at every scenario and to, just clearly articulate what the potential benefits are and what the potential risks are. But when we talk about risk in this scenario, it's, the likelihood of the IRS coming back, of picking up your return and also being able to clarify their own position in a way that, makes your return position, null and void is, fairly unlikely, just like statistically speaking. But it doesn't mean that you don't do all the necessary work up front to cross your T's and dot your I's.
Yeah, and there's a little nuance to that is maybe important to understand. Right, if I have taken a position on a tax return, and then the IRS changes the rules on me after the fact, right? When I assess, did I have a valid reason for taking that position, right? The rules are pretty clear that you would make that determination based on the authority that was available at the time you took the position, right? So future issued authority is not going to apply retroactively to say that was completely unreasonable because the IRS said so 18 months later. So for penalty purposes, right, it's not entirely relevant. However, just because you took a position and you could do it ethically on your tax return doesn't mean that IRS will agree with it, or more importantly, that the courts will agree with it if and when you litigate it. So, there are very few bright lines in the tax code, specifically in 1202. But
we have about a dozen private letter rulings out there around Section 1202, and most of them have been fairly expansive, in my opinion, in terms of their interpretation of the code. And so I think that's a positive on these fronts, and hopefully with more use of QSBS in the future, we'll see more guidance from the IRS on it, or so that's a hope, because more clarity would benefit everyone, I believe.
Yeah, it would, and I think especially if you see some of the bigger players going into the space, you likely will, right? Because getting a private letter ruling is expensive.
Are they even issuing them for 1202 type things anymore? I had thought that they stopped issuing them.
I'm sure that there are some issues you could get a ruling on.
Okay.
There are always some that you can't, but assuming that it's an issue you could get a ruling on, I don't think they're going to tell you that's a good qualifying trade or business, right? But there might be something else that they would rule on it. But even then, once you pay the lawyers to draft all the memos and have the meetings and convince the IRS that you're right, you're basically doing it's a private litigation almost in some of these cases. And so you could be looking at $100,000 before you wake up in the morning to get those rulings. So most people are not getting them, right? They're just kind of assessing risk and taking a position and going on about their business.
Yeah. Mark, thanks for your insight here today. It's always good to talk about risk, what it is and what it isn't. And hopefully we can have you back on later in 2026, and maybe we even have a little bit more clarity over the next 1 or 2 years on some of these things, and we can have a more black and white conversation.
Yeah. Well, clarity is good for knowing what you can and can't do. It's a whole lot less fun to talk about, though.
That's right. Yeah. Yeah. Thanks, Mark. And we'll talk to you soon.
Okay. Thanks, Brady.
Thanks for listening to this episode of QSBS Solved. We hope to hear from you soon. Remember that the content shared on QSBS Solved is for informational purposes only and should not be construed as legal, tax, or investment advice. While we discuss strategies related to qualified small business stock, or QSBS, including rollover planning, listeners should consult their own tax, legal, and financial advisors before making any decisions. Laws and interpretations can change. Individual circumstances do vary.